Okay, class. Finishing up Chapter 20 with Part 6. Another federal law protecting us in in various situations is group-sponsored health care plans. And that's the Health Insurance Portability and Accountability Act that went into effect, about 5 years ago now? And it has to do largely with your health care records and who can access them and how they are kept by employers and by healthcare providers. It restricts the manner in which employers collect, use, and disclose the health information of employees and their families. Employers have to designate privacy officials, distribute privacy notices, and train employees to ensure that the employee's health information is not disclosed to unauthorized parties. HIPAA violations are subject to fines and criminal prosecution. The Affordable Care Act, Obamacare as we know it, requires most employers with 50 or more full-time employees to offer health insurance benefits to their employees. It gives tax benefits for those offering those health care benefits. If the employer who is covered by the law fails to provide those benefits under the statute, they can be fined up to $2,000 for each employee after the first 30 people. Also, they can be assessed a penalty if the charge to the employee for insurance exceeds 9.5% of that employee's compensation. More laws regarding employment. Electronic monitoring. More than half of employers today use some form of electronic monitoring of employees. There are some minor protections under privacy laws and under tort laws and under state constitutions that do protect employees from some of these invasions of their privacy. State and federal statutes may also limit an employer's conduct in certain respects, but employers still have a lot of leeway in monitoring what you do in the workplace. This is particularly true with computers that belong to the employer. In addition to monitoring online activities, employers engage in other types of screening and monitoring. Some of these have been challenged as violation of privacy rights. Let's look first at lie detector tests. There's a federal law called the Employee Polygraph Protection Act that prohibits employers from requiring, suggesting, or requesting employees and job applicants to take lie detector tests. That's the broad coverage. There are a lot of exceptions. It also restricts employers' ability to use or ask about any lie detector test results or to take negative employment action based on those results. Exemptions include government employers at all levels, certain security service firms, and companies that manufacture and distribute controlled substances. What about drug testing? Many employers require their employees to submit to drug testing in the interest of public safety and to reduce unnecessary costs. Government employers are constrained against drug testing by the Fourth Amendment. It's considered an illegal search and seizure except in certain circumstances that meet Fourth Amendment requirements. Testing is allowed by statute for drugs for transportation workers who work for the government. That can occur when employees have a certain job that may threaten public safety, or there's a reasonable suspicion of drug use. So anytime you have, for example, an accident involving a train or a bus or any kind of public transportation, usually the driver or the engineer is going to be required to take a drug test, and that's allowable under this exception. Private employees, the Fourth Amendment doesn't apply. Many states have statutes that allow drug testing by private employees, but restrict when and how the testing can be performed. Oftentimes it hinges on a reasonableness test, whether the employee's testing is reasonable. So zero tolerance policies and random drug tests have been held to be reasonable. Okay, so final point. Many of these laws we talked about, and I stated which ones we were talking about, are federal laws. Remember that the federal government can only make laws that affect us if it has a provision that it can point to in the Constitution that authorizes it to do so. For most of these situations, that authorization is going to come from the Commerce Clause that we talked about in previous chapters. The interpretation by the U.S. Supreme Court of the Commerce Clause can have a big effect on any of this. An example is the Affordable Care Act. The Affordable Care Act, if you don't know, was challenged in the courts as being a violation of the Commerce Clause. Those who challenged it said that Congress went too far and did not have the authority under the Commerce Clause to pass that law. It was a test not only of Obamacare, but also of the Commerce Clause. And it's fair to say, I think, that Obamacare would have failed under the Commerce Clause. However, unbeknownst to most legal scholars, the government, in their defense of Obamacare, argued that they had the authority as a act under the Commerce Clause, but also under their taxing power. So the fifth vote upholding Obamacare by Chief Justice Roberts was based upon the taxing authority and not the Commerce Clause. Justice Roberts finding that Obamacare was in fact a tax and Congress had the authority to do so. So be aware of that. Why? Because it's an area that we're going to probably see a lot more court involvement in interpretation of congressional acts, including subsequent healthcare acts and things of that nature. This concludes Chapter 20. Again, the magic word for Chapter 20 is discharge.